Okay, good afternoon. It's 1 o'clock. We're here today for a hearing, what's called a sanctions hearing in case number 5D20-2325. I am Judge Lambert. I will be presiding over this sanction hearing. With me on the panel are Judge Meredith Sasso and Judge Dan Traver. The hearing is in response to a December 15, 2020 order directing Attorney Eduardo, how do you say your last name, sir?
Mejias.
Mejias, directing that he personally appear before us via remote video conferencing to show cause why he should not be sanctioned for failing to respond to this court's orders of November 5, 2020, November 16, 2020, and December 1, 2020. Okay. Mr. Mejias, you were, let me just set the stage a little bit. You were the trial attorney for the mother CS in this case?
Correct.
And were you privately retained or were you appointed by the trial court?
I was privately retained.
Okay. All right. Well, the record seems clear that we did not get responses from you within the time frame set forth in the respective three orders that I just outlined. This is your show cause hearing, so I'm going to let you provide us all the reasons you believe why we should not impose sanctions upon you. So go ahead, sir.
Well, respectfully for the court, Your Honor, ladies and gentlemen, I did file a response. I e-filed a response to the order of show cause yesterday, which has been docketed. It explains my position very well, but I can gladly go over with you verbally. I really do believe that there's been a misunderstanding here. Let me backtrack. I represented Civica Simpson, the mother, in an underlying dependency case in Seminole County, case number 29 DP 000122. And we went to a dependency trial, and we had an order that came out from Judge Lester October 28th. After the final judgment was signed on October 28th, I offered Ms. Simpson, I offered my services to file an appeal of that final judgment. But she ultimately decided to file the appeal of that judgment on a pro se basis.
Well, let me make sure I'm clear first, a little bit of the chronology. The actual final judgment on the adjudicatory hearing on the dependency petition as to your client was, as I understand, filed on October 5, 2020. I'm looking at 11/16/42 a.m. filing date or filing time of that date. You're referring to an October 28, 2020 order. Is that an order on her pro se motion for rehearing?
No. Let me apologize. The final judgment was October 5th. I misspoke. However, a week after October 5th, Ms. Simpson and I discussed the possibility of appealing the final judgment, even though the order reunified her with her children. She wasn't happy with some of the language in the order or in the order from the adjudicatory hearing. However, about 7 to 10 days after we received Judge Lester's final judgment, she decided that she was going to appeal on her own, that she was going to appeal pro se, that she didn't want to pay me my retainer for an appeal. So then on October 28th, I filed a motion to withdraw from the underlying dependency case. That's what I meant by October 28th. The very next day, and also sent an order to Judge Lester. Judge Lester signed the order withdrawing me from the dependency case.
Just so we're clear, since this is on YouTube as well, so it's being streamed. That October 28, 2020 motion that you filed, you sent copies to the opposing counsel. I'm looking at the certificate of service. There does not appear to be a certificate indication that it was sent to your client, nor did she sign off on. Is there a consent? Is that accurate? There's no written consent attached to the motion?
No, there was not a written consent. That's true.
Okay, and I noticed that the next day, the judge, Lester, did sign the order granting your motion to withdraw and sent it to apparently your opposing counsels. Uh, You're familiar though with Rule 8.517, right? Florida Juvenile Procedure Rule
Yes.
regarding with withdrawal and appointment of attorney here, and there's certain requirements that have to be that the attorney has to do discussing appellate remedies, and if the client in this case proceeds forward with an appeal as your client did. I know she filed a note or pro se notice. There's certain things you still have to do though before you withdraw from a case. Don't you agree? Doesn't the rule kind of spell that out?
Well, no, I don't disagree with that, Your Honor. You're right. Uh, but Ms. Simpson and I thoroughly discussed her options. She
Right.
chose to file the pro se appeal. I forwarded her the motion to withdraw. And I realized I didn't include her certificate of service, which is my mistake. But I also sent the motion to withdraw to several of actually all the opposing attorneys before I filed it. So actually, I drafted it about October 20th. I sent it to all of the attorneys on the case. None of them had an objection to it. My client had already authorized me to, in fact, she was insisting that I file a motion to withdraw because she wanted to proceed by herself.
And
So then what?
in your defense, in her
Yeah.
motion for rehearing, she did make comments about your representation at the trial. So what you're saying to us now, that she didn't want you to proceed representing her on the appeal that's pending now before us of this final judgment, would be somewhat consistent with her views of your representation. Have you seen her motion for rehearing, her pro se motion for rehearing after the October 5 final judgment?
I did not read the motion for rehearing. No.
Okay. Well, I mean, and we get it. I mean, we obviously see motions for post-conviction relief for people in criminal cases, complain about their lawyers all the time. And I'm not saying it has any merit one way or another, because that's not the issue before us. But she did say that she thought there was a couple things that she wasn't happy with your representation. Now, she obviously lost the final, she's appealing, or she perceives she lost and she's appealing. So that being said, but in any event, there is still requirements that the trial judge should have guaranteed that you had met under 8517 before allowing you to withdraw. Do you agree with that general concept under the rules?
Yes.
Okay. It kind of begs the question, though. You filed your response yesterday. I've looked back through the record of the pending dependency hearing, and I see these things. So I'm trying to piece this together as we sit for the sanction hearing right now. Why didn't you just say something to us in response to any of these orders, saying, judge, judges, I was privately retained. I'm not in this case anymore. The mother has filed her pro se notice. She's responded to the juvenile expedite order, I think 10 or 11 days after we issued it. It looks like, the case is proceeding without me. I'm not involved. Sorry.
I'll be honest. When I received the order from Judge Lester withdrawing me from the dependency case, I knew that Civica would file a notice of appeal, but I know she hadn't filed one yet. I have a virtual office, and I've had one really since even before COVID. And I go to my satellite office, if you will, about once a week. I received the order to show cause on, I think it was the 15th, or it was in December, and I filed the acknowledgement. I was not looking for it because I really honestly thought that I was out of the case, and Civica had confirmed with me that I was out of the case, and Judge Lester had confirmed. If she were to file an appeal, which I knew she would, I didn't think, based on what I had already been ordered to withdraw, that I would have to clarify my status in the appeal. I honestly didn't think that. In retrospect, I should have made it clear that I was not her attorney. I admit that. But when I received the order withdrawal, and I know that she hadn't filed the notice of appeal yet, I thought that that was the end of my involvement with her and
Well,
all the
it may
dependencies.
well have been. I mean, I get the sequential logic to that, setting aside 8.517, that perhaps missed a few steps along the way. But I mean, at some point, you get an order from us. I mean, you're on the certificates of service, and I think our clerk's office confirmed that they actually went to you. So you get an order, and it's saying this, and then you get forget about the juvenile expedite order just for a second here, but you get the second order saying you haven't done what we needed you to do in the November 5 order. Please, tell us why you haven't done it. I mean, a simple response of judges, we got your order, or DCA, we've got your order. I've got your order. I'm no longer counsel of record. It appears that she's filed these things. I was granted leave to withdraw 3 weeks ago. Respectfully, I'm no longer in this case. If you have any other questions, let me know. And I suspect that would have ended our paper sending. No, I didn't mean paper sending. That would have stopped our sending to you of orders. And I mean, and that's the frustration here. These are court orders, whether you think they are substantively correct anymore because of Judge Lester's order, of which we don't know anything about.
Realize that now, yes.
Somebody needs to tell us that, because now, we've all gathered together. Obviously, I've spent time, I'm sure my colleagues on the panel have spent time getting ready for this hearing to find out, well, what's going on with this gentleman, with this attorney? Have we had any issues with him in the past? Is something going on? Is he's having, there's something going on with your practice that you're having a hard time complying with court orders that we need to know about, because over and above not responding to our orders when we direct you to do that, if you're not being responsive to your clients, that's a concern in the big picture here. And come in here today saying, well, I filed my response to your show cause yesterday. And I mean, even your motion and your order, it's been rejected for some, procedural reason in the clerk's office. So I pulled it from the actual record of the direct appeal. You've caused us to go through this. It seems unnecessarily, certainly for us, and I would assume that you'd prefer not to be sitting here with us at this sanction hearing, right?
I apologize to all of you for having your time and energy and resources devoted to this order to show cause hearing. I should have been more diligent in literally responding to the original orders sent in November. If I had actually seen them in my mail, which is my fault, I definitely would not have just ignored them. I would have responded with a similar.
How do you not see those orders, but you see the December 15 order that tells you to file an acknowledgement, which you timely comply with? I mean, why is that?
It was sheer happenstance. It could have been that I just overlooked the original orders in my physical mail. I wasn't looking for something in this case. It just so happened that I noticed the order to show cause, and of course I responded to it. But
Mr. Mejias, hello, sir. What's your office situation these days? Do you have anybody helping you?
Yes, I do. She works remotely from a different part of town. I work from Lake Mary, Florida, but my satellite office is still in Altamont Springs, as it has been for a while.
How many cases are you currently assigned or working on right now?
Between 50 and 60.
What procedures, if any, do you have to make sure, working between you and your legal assistant, that mail like this isn't missed?
Well, the procedure we're going to be doing from now on, Judge Traver, is we're going to be moving because now it's allowed, at least we're in Seminole County, a physical integrated office like we had before in Altamont Springs. We moved out of Altamont Springs as a primary resident back in December of 2018. Since then, we've been able to manage, but there have been instances where mail has just not been picked up. And that's one of the reasons we're moving back to a physical centralized office.
I mean,
where both me and my
To me, and I think Judge Lambert alluded to this, the concern that I have for you personally is that if this is the way that you're addressing your incoming mail in 50 to 60 pending cases, then, you miss something that has a deadline. You find yourself in a different issue. So to the extent that this is about office management, other than that rough plan that you just outlined, what, if any, other steps do you have to remedy this issue from not happening again in the future?
Well, I go to the satellite office Monday, Wednesdays, and Fridays, even if I don't have to meet somebody there, just to pick up the mail. It's about a 15-minute drive from my residence.
How are you otherwise staying on top of deadlines in your respective 50 to 60 cases?
Well, not all, but most of the orders and pleadings I receive are via email, and I am constantly checking my email.
Do you have a separate calendaring system?
Yeah, I use a regular calendaring system. Whenever it's really whoever gets to it first. If my assistant sees that there's an order for a hearing or notice of hearing, she'll calendar it. If I see it first, I'll calendar it. I do have it. Yeah, of course. I use Google Calendar. We've been using that since I started the practice back in 2013. So yeah, we have a calendaring system. The problem has been occasionally that everything's not inputted into the calendar. And that is something that needs to improve.
Are you saying that you didn't get the November 16 order, November 5 order, December 1 order? Maybe I'm misunderstanding some of your responses. I mean, were they sent to you in the mail and you didn't get them, or weren't they sent by email? And
I'm not saying, Your Honor, that I did not get them. I didn't claim that.
Okay.
For whatever reason, I did not notice that I had received them in the mail like I did the order to show cause.
Mm-hmm.
If our system indicates that you acknowledge the email on the November 15th order, or yes, November 15th order to show cause on November 16th, is our system accurate?
Sorry, can you repeat that?
Yes. All right. And can y'all hear me okay?
I can.
Yeah, okay. I can hear you.
I was having audio issues earlier today. If our system indicates that you acknowledge the initial order to show cause on November 16th, and in other words, indicating that the email was opened on November 16th, would that be inaccurate, or could that be consistent with your recollection of the events?
No, that is consistent with my recollection. That is true.
Which begs the question, well then, it tells you to show cause and you didn't do anything, and why would that be?
What I could say is I filed the notice of acknowledgments.
Well, that's a later order. This is the one, if you would have responded to this one, we wouldn't be here. That non-response to that one led to the December 1 order, and the non-response to that one led to the December 15 one that sets the hearing today, and you acknowledged it, and then you filed your response as of yesterday, I believe. And I guess it seems like our orders are not, because you said, well, I was granted a motion to withdraw by the lower court, that our orders were not properly addressed. Whether you agreed with the entry of the orders or not, you still need to respond to them. And I'm not understanding why you didn't. It kind of reminds me, I used to be a trial judge for a long time back in the, just the mailing days. And I used to hear this, I didn't get it. So I had a way to resolve this, as I actually, my JA would prepare the envelopes, I'd stuff the envelopes, and I drove by to the mailbox and dropped them off on my way home. So anybody who was saying it was not mailed or couldn't, they were basically saying I didn't mail it, and I know I mailed it. So, and what would typically happen is when there was finally an order or a judgment that might have significant consequences, those are the ones actually anybody said, well, I got that one, so I'm here. And it's like, well, we wouldn't need to be here if somebody had responded along the way. And that's, That's the frustrating thing here. And
I
that's
know.
the bigger picture is you have clients that may be adversely affected by you not responding, because if we don't hear anything, order to show cause why this appeal shouldn't be dismissed because no brief's been filed, and we don't hear, then we dismiss it. And that's not the client's fault. And that's what we're trying to figure. How does this get avoided in the future? What assurances do we have when you apparently, as Judge Sasso, you've acknowledged receiving these orders, opening these orders and looking at them and not taking action until we get to the point of, okay, what sanction, if any, should we impose upon you? Now we're having a more, frank discussion about it. And that, it just seems unnecessary. And we weren't asking you to write a 40-page brief. We're just saying, what's going on? Tell us what's going on.
I acknowledge that I was remiss in not responding to the earlier orders. That is my fault. I had mentally disassociated with the case once I got the order of withdrawal, and I did not check to see what these orders were actually saying until, of course, the last one, which led us to today. I promise I will make every effort to respond to every order from this court and other appellate courts, of course, too, and other trial courts, which I usually do. But I don't have any excuse other than to say that I just overlooked it, those first three orders. I apologize for the time and energy this court has taken to address this.
Okay. Anything else anybody want to ask counsel? Anything else you want to say to us before we conclude the hearing?
Well, I've been practicing in front of the appellate courts as an appellate attorney for several years now. Except for this case, I've always tried to conform to the appellate rules of procedure, to respond to orders to show causes, whether it's something as minor as fixing a font or not complying exactly with a format or something like that. I've done that several times. This is just the one time where I didn't properly pay attention to the orders. I hope this court can take that consideration, that I do respect what this court orders. And I know no way, shape, or form was I trying to disrespect the court by not responding quickly enough.
So you're saying you've represented clients before us, and there's been no non-compliance with orders or no orders to show cause. And I mean, other than the font issue you said.
This is the first order. Well, I've been appealing since 2013 or so. I've presented appeals to 4 of the 5 DCAs of Florida. I have 2 current appellate clients that are actually on appeal. This is the first hearing that I've been called to as an attorney for an order to show cause. I've had to correct errors in filings. I've done that several times, but this is the first hearing for this purpose that I've been called to by an appellate court.
Well, this is the first hearing, maybe. But I mean, I thought I understood you to say you've had others. You've represented people here in the past, clients in the past, in front of us, and you've never had issues of not responding to court orders.
No, I have not. No, that I've not done. The only issues, if you want to call them, that I've had is correcting filing mistakes, which I always did promptly within the time. But this is the first time that my delay has caused an order to show cause hearing.
But orders to show cause they've had. I mean, because we pull your name up, right, on your doc.
No, I'm not. The order to show cause have been for things like filing errors okay. Another example would be not the appellate filing fee not being paid on time, which happens sometimes. But I've always responded to those orders with either the filing fee itself or correcting the pleading. So all I'm saying is that this is the first hearing I've had like this for an order to show cause in the appellate practice.
Well, I think I agree with this is the first hearing on an order to show cause. I don't know that I don't think this is the first order to show cause on other cases, though, as to other cases when you've been counsel of record. So, okay. Anybody else have any questions or comments for council? Okay, council, anything else you want to say? I'm not saying you have to, just give your, your chance to say anything else you think you want us to know.
Well, again, I deeply apologize for overlooking the early orders, and I promise it won't happen again.
Okay. All right, then we will stand adjourned, and my colleagues and I will talk about this hearing in
Yeah.
private. So, okay. Our hearing now is canceled.